Yeah, 137. But some urgency is there because my lord, the people are not getting the salary since last 3 4 years, man. So last 3 4 years, man. He has been working in the post of
Now it is at 137.
Yes,
Then don't mention. It will come.
sir. My larger friend is here.
If it is at 137, you are fortunate. It will be taken up very soon. Yes.
Since your lordship has not indication that hearing matter will be taken up this day,
Which matter?
the hearing matter.
Oh, it's under hearing. So we'll do that. Let's see. We'll work out how many matters are pending. We'll. So you can get it whenever you get. You will get everything. It was part heard. What is the number of the case? No, but it is fixed for today. That is why we are asking you. It is tentative. Why it is not in the list? Find out. Should have been in the list today. It says is to be listed on 6/11. No, get the file. Get the file immediately. Get the file immediately. There's a request of the Supreme Court to get it. Get the file.
It's a matter of appointment of very short PAPA.
Yes. Arising out of?
Disposing of the
Why without a certified copy?
because the vacation was there, so it's not very different. But the urgency is on the both sides. What has happened when people are applied? The height restriction 1.7. All people are 1.65 is a 165 16.50. Now the court has allowed them to appear in the recruitment process. They have been short of height. A short point in 1 minute and
You are for the
not for the six settlement the content they are filed.
What is happening in the contempt?
Yes, the Friday is fixed for
Let us see the order. No, the contempt order. Where is the direction for personal appearance? This one.
Let me have your lordships.
This appearance is because of a different reason. This appearance is because nobody was appearing the accepting the notice and appearing.
Yes, no, yes.
That is the context in which he has been directed to appear. Nobody is appearing. That's not for compliance of the order. You wait for some time. Yes. Why, sir? How much time? It is now beyond the limitation. So you file it with the certified copy.
6% the pending. I'm not getting the file. But then start with the main file. File.
I'm for myself speaking for myself. I'm unable to understand what you are saying.
The main file is the content file.
Yes. Why?
Main file start with the.
So therefore, nobody will get a certified copy.
They will not.
Show the procedure that you will not get a copy as long as it is tagged with the contempt proceeding. You go and mention before the bench. You know better what to do. Why certified copy is not being given to you? You have already crossed the limitation. You could have come within limitation. If it was within limitation, we could have understood. You have already crossed the limitation. You will have to file a section 5 anyway. So you do it. Sorry. No.
Scan file for the new.
Everybody does it. Why not you? Yes.
My lord, may I have your lordship's kind leave to mention, my lord, one contempt application, my lord. Your lordship passed an order sitting with Justice Bhattacharya, my lord, on 10th December 2024, my lord, allowing the petitioner to get the benefits of 16th September 2011's benefit. My lord, that has been affirmed. Your lordship's order has been affirmed by the Honorable Supreme Court also, my lord. But my lord, the contempt application, my lord, they are still, my lord, not complying with your lordship's order, my lord. So, my lord, and the contempt application is pending, my lord. In today's list, my lord, it is 101, item number 101. So, my lord, kindly take up the contempt application, my lord.
It will come on its own turn.
My lord,
Sorry. Yes.
Well,
We remember we have heard it. Yes.
the lordship's order has been affirmed by the Honorable Supreme Court, my
So
lord.
therefore, must be given precedence over all other cases. Yes.
So Lordship, may I be permitted to mention for inclusion in your Lordship list the appeal?
Give the inclusion matters.
Lordship,
Anybody who
because-
wants inclusion, you give it.
Yes, the urgency is, Your Lordship, the urgency is the respondent number 1 has filed a contempt application and a rule has been issued. This is the urgency on
What urgency? You file your show cause or whatever reply you have to file there.
I have mentioned that the appeal is pending. The Ken application has been filed regarding operation of stay. The Honorable Single Judge has observed since there is no order of stay, there is no impediment to proceed with
So if
the
rule has been issued, what are you required to do?
Your Lordship, the Honorable Single Judge has directed.
If rule has been issued, what are you required to do?
Lordship, the rule has been issued to the Lordship. I have to show cause as to why the order has
Then
not
file it. What is the big deal? It will be it will come in the it will be included in the list. Yes.
Can you give some precedence? subject
No,
to-
let it come in the list, then we'll see. Yes.
Oblige, Your Lordship.
Yes.
I have your lordship's kind leave, my lord, to mention the matter which your lordship was pleased to refer for mediation, my lord. Mediation matter. If your
Oh,
lordship
that where the
and
sister and mother were. It has been settled. Where is the other side?
on 29th it was settled. I told them on the mediation.
So we have fixed some time in that.
Referred for mediation. That's why no time has been fixed, my lord. If it can be kept under to be mentioned,
No, while referring for mediation, we have not said that.
there was a time limit, my lord.
Correct. So when that time limit lapses,
Matter has been settled on 29th of October.
when the time limit lapses, the report of the mediator, is it there in the file? When is the date? We must have fixed a time or date for the report of the mediator to be submitted. What is that date?
8 weeks from date, my lord. It was referred on 3rd of September 2025, my lord.
8 weeks has lapsed. Well, next week it will come. You give the slip. Next week. Monday next. Monday week. Why are you mentioning? We already said all inclusion you give, it will come in the list.
Any mention what matter? This is of code number 12, group 7 matter.
Why you are mentioning here?
Because your lordship has given, this honorable bench has given determination from today till 14th.
We have yet to see it.
Lordship, can you see লিস্টে দেখুন, লিস্টে লেখা রয়েছে।
It's in the list.
Yes. Get in the cause list. I have seen in the cause list.
So what do you want?
For inclusion of the stay application. Because there are some urgency in this matter.
For inclusion, we are just see what the determination says. So please read the determination. We are to take up urgent matters. If some order is to be passed, we will take it up. For filing, why should you wait till the bench comes?
It has been filed prior to the vacation. Prior to the vacation.
Then what is the urgency?
No. Your lordship can see it was filed just 2 days before the vacation. Then it was there was no time to get included in the list. After vacation, I was the impression it will be included.
So you remain in that impression for 1 more week. Let his lordship come, then you do it. Yes.
For 1 more week.
Till 14
10 days.
So you wait. Yes.
But may I permit to mention one WPST matter of 2025, my lord. This matter was moved before, during the vacation bench, my lord. This matter relates to recruitment of facility manager grade 3, wherein, my lord,
What do you want?
for urgent hearing.
Where is the matter?
Well, it's not. It was moved before the vacation bench. The coordinate bench had directed the state to file a report, my lord, within 2 weeks, my lord. If your lordship kindly have a look on the order.
Lordship, can be kindly permitted to mention a couple of infructuous matters.
One of the urgencies that the recruiting body may any day conduct the CBT, my lord, making by OA infructuous.
Matter is before us. WPST. The urgency. The report has been
urgency is that, my
directed
lord,
to-
but herein we have challenged the recruiting bodies permitting all the participants to
All right,
participate in the
we'll
CBT.
see when it comes.
But since the tribunal is currently defunct, my lord, we had filed an application. to
Right,
the
let
vacation
the
bench.
report come. It will be listed as per the order. Don't worry.
Lord, no date has been mentioned here, my lord. But they may any day conduct the CBT, my lord, making my application infructuous, my lord. The card,
No date has been fixed.
it is only written that it will be placed before the regular bench, my lord. No date has been fixed, my lord. But should kindly takes it up any day next week, my lord. My application
You mention in the next week. Yes, call the list.
as your lord.
Item number 1.
State, my lord, compliance of your lordship's earlier direction, my lord, may I kindly.
Oh, sorry. Yes, Oscar, she was mentioning some matter. Sorry. Yes, you wanted to mention. We are sorry. We missed. Yes.
Couple of infructuous matter. Your Lordship, I'm for the respondent union. If your Lordship kindly includes it as
It's an infructuous matter.
these are all infructuous matter.
Why it is infructuous?
Been pending since 2020.
How many matters are there?
5.
Oh, why it is infructuous? Why do you say it is infructuous? What is the issue?
Have the necessary information regarding that.
Please find out. Come with the details tomorrow. Tell us. We'll get it listed for disposal.
Item number 1, I am for this petition led by Mr. Lokinath Bhattacharya, praying for not today, lordship.
Who?
Mr. Lokinath Bhattacharya, advocate on record, my lord.
But I am otherwise ready with the report, my lord, in compliance of your lordship's direction. My lord, tomorrow, instead of tomorrow, kindly make it not this week. Otherwise, I am ready today with report.
As prayed, matter is adjourned for the day. Tomorrow.
Tomorrow, there is some difficulty, my lord. Day after tomorrow, my lord.
So
Monday,
then not today with note, give a note tomorrow, not today. It will automatically come on Monday.
great, sir.
No, tomorrow with not today.
Order for signing. Item number 2. Yellow red.
My lord, item number 2, my learned senior has gone to the Supreme Court. So kindly not this week, my lord.
Let us see. Yes, not today. You want not today?
Not this week, my lord, not today or tomorrow. This week is finished.
As prayed by petitioners council.
Item number 3.
I am for the petitioner in this matter. Service has been affected. Has come up against an order of West Bengal Administrative Tribunal. The short fact that
উল্টা বলছি তো হ্যালো ফাঁকা 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 আর
the short facts are that I had made an application for on the grounds of compassionate appointment. However, there was an inquiry conducted by the authorities. That inquiry report was never served to me, and thereafter, from the impugned order, it can be found out. Firstly, comes to the second page of the impugned order. It reflects line that during the hearing of this matter, the respondent authorities presented a copy of the inquiry report. Page 88 of my petition. Fifth line.
No, but you have not disputed the finding of the report.
Rashid, I have never been served with the report since the inception of the proceedings. Now, may I indicate the
You must have gone through the tribunal's order.
Rashid, from the authorities order, since there the inquiry report was relied upon, but the inquiry report was never served upon me.
Again, we are asking you. Again, we are asking you. You must have read the tribunal's order.
Yes.
The tribunal records that copy of the inquiry report is being given to us, and it says you do not dispute it.
Rashid, I do not dispute it. I could not have because during the hearing.
Can you say that here? Is this forum available for saying that?
Understand. But
no, if you understand, that is why we are asking you, because we expect you to understand. Once there is a recording that you do not dispute a fact, can you come in appeal to challenge that document?
But I have.
Or in a writ proceeding? That is the only issue. Once you cross that, we can see everything.
My case is that I have been asking.
We are asking you with once you cross that, we can hear everything. Is this the forum or you are required to do something else if there is a wrong recording of a statement of facts?
I need to file a review petition.
Obviously, then why are you here?
But in the
Should we start doing this in every case? Can we do this in every case? Then if not, then why in your case?
I'm only praying. So I can. From the facts are clear that since the inception of the proceeding.
Either you proceed on the basis of this finding that you do not dispute the findings, then we are going to hear you. Why family pension should not be included. If you are on the point that though you were not served, it has wrongly been recorded, you avail the remedy. What do you want?
So may I only get that liberty to file a review petition?
Yes. The learned advocate.
I'm great.
Item number 4.
And 5. That the petitions in respect of one petitioner, the common person,
Same petitioner.
same person, with
Oh.
two different cause of actions. In item number 4, I am seeking an interim relief to protect me from any type of coercive action. Already the action has been taken. But a tribunal is not available. I cannot get myself hurt. Now I pressed for the interim order, which was not granted. Now I will come to item number 4. Item number 5. Item number 4. That is WPST 225 of 2020. Okay, here, kindly come to the order passed by the tribunal. It will be found in volume 2, last. It starts from page 172 onwards, certified copy, page 172A.
What is the relief you are claiming in this? Before the tribunal, what was the relief that you claimed?
Well, this application, the 173, I prayed that application under section 19 of the Administrative Tribunal Act 1985 has been filed
No,
by
no. In your way, what is the relief that you claimed? Come to page 41 for disposal of your appeal.
41, Lordship, kindly come. An order to issue upon the respondent authorities, thereby setting aside the quashing, modifying the order of suspension dated 8/8/2025. An order to issue upon the respondent authorities, thereby setting aside, quashing, and modifying the third show cause.
Show cause. Suspension and show cause. Why?
My lord,
Under what circumstances suspension and show cause is to be quashed?
Lordship, in this particular matter, there is double jeopardy. What has happened, Lordship, in 2016, they initiated one inquiry against me. That inquiry was culminated in 2019. By this time, 2017, they published one advertisement, inter alia notifying the recruitment of interdepartmental recruitment by way of promotion. I participated in that. When I participated, no objection was raised, but when the result was published, my name was not featured in the final list. So I challenged that decision before the learned tribunal. Learned tribunal, Lordship, initially, while disposing the first Vedidan, directed them to consider my representation and pass a reasoned order. When they passed a reasoned order in 2019, they said that this particular person, there are the vigilance proceedings which are pending against me and other proceedings are pending against me. Now they started the parallel disciplinary proceeding against me after that. There was one inquiry that was culminated after a long time. They did not do anything. They suddenly wake up from this slumber in 19. Now that was the malafide on their part. So we challenged this third show cause also on the basis of that. And also they have registered the FIR against me. And FIR, Lordship, will be found page 172.
So therefore, what is the ground for challenging a show cause? Again, we are asking. The facts may be whatever they are. A show cause, whether a show cause causes any prejudice and whether it can be interfered by in the judicial review. So let us see. That's what we are asking you to begin with.
In a limited round, Lordship, that case show cause can be challenged once it is issued in malafide. But Lordship, I should be equipped with that judgment. I have that judgment, Lordship. Kindly give me one day time, I'll produce that judgment.
Come.
There is one judgment, I will rely on that.
Not today.
Both the same matter, Lordship.
Both will come together tomorrow.
Lordship. Item number 6.
Your notice has been issued. Yes. So what do you want? Yeah, this has been served on you. The supplementary affidavit.
They have recognized, they have given 1/3 of some dues. For the other dues, they are not. Item number 7. Recognizing her, the legitimacy of her claim.
Mr. Uttiyo Rai appear on behalf of petitioner. Due to illness, he could not come, my lord. On the occasion, he has lordship reaction to affidavit opposition, my lord. Till that, not file his affidavit opposition, my lord.
Reply you have filed.
Oh, my lord. State.
Opposition has not been.
Lords.
The time for
Item number 8.
May I please your lordship? And I'm for the petitioner, my lord. Last occasion, your lordship was pleased to hear the matter at length. Lastly, your lordship was pleased to direct me to serve copy of the judgment, the latest judgment, which I have relied upon to the learned advocate for the. I have served, my lord, on that day. And I am referring the paragraphs.
You have given him today. Have you given him today? Mr. Mukherjee, have you got copy of?
Yes, sir. Facts are different.
No, so we should proceed. As played by learned AGP.
Item number 9.
8, 9, 10, 11, and 12. Is the identical.
8 to 12 altogether.
I'm trying the same order.
Same on. Up to 12.
And it's same as
Item number 13.
Not today. Not today. All the next.
Fourteen.
I'm appealing for the petitioner lordship.
And who is for the respondent? You are for the respondent.
The last occasion I made my submission, lordship. This is in respect of
Find out that time. Yeah. Me. Don't change it. Don't change. Yes. Right. Oh, yes, you were saying that the cutoff for the general is fixed lower than the OBC.
yes, lordship. And my application was rejected on the ground of delay, and I have submitted that there was no delay on my part. Lordship was pleased to ask the respondent whether they have taken any point in the OA application regarding whether they have filed any opposition taking this point, lordship.
Yes, we were wanted to know whether opposition has been filed or not. You filed it. It is in the paper book. And where's the tribunal's order? Which page? All right, we have it. It is of 110/24.
Yes, Lordship. I did not find any opposition of OA in the paper book,
No, no.
Lordship.
147.
That is in the present proceedings before the Honorable High Court, Lordship.
No. We wanted to
Yes,
know
Lordship,
whether they have filed in the
Any
OA.
opposition has been filed in the OA.
Yeah.
OA, though I could not find any opposition filed by them.
No, good.
You have not filed. Then how you are saying you have filed? Then let him file if he has not filed.
Lordship, in this proceedings before the High Court in respect of this.
Here they have already
insti
filed.
they have filed.
Where is that?
Yes, Lordship. 147.
Now you have filed, then we can proceed.
And but that thing has been discussed.
This is for the written test only.
Yes,
This is
Lordship.
not the final cutoff mark.
Written test.
Ultimately,
They have not given any answer in this affidavit why the cutoff of OBC was higher than the unreserved, Lordship.
in final, cutoff marks for OBC B is 87.5 and general candidate 88. Right? Scheduled tribe 2.35, OBC 55.35.
That is why we asked you.
That is in respect of the final. I was rejected at the stage of written test. Therefore, I have asked for the cutoff marks in the written.
You were rejected at the written stage.
Yes, Lordship. Then I have made an application asking for what are the cutoff marks. Then initially I was not replied. Therefore, after I have filed a writ petition by order of the Honorable High Court, they have supplied us the cutoff marks. There I found that the OBC B category's cutoff marks is higher than the unreserved category. Thereafter, I've made another RTI application, but I was not given any answer, and I've approached again the Honorable High Court, and Honorable High Court has asked us to file an application before the administrative tribunal. I have made an application before the administrative tribunal. There, my case was rejected on the ground of delay without considering the merit. Therefore, I am before this Honorable Court.
Yes, so the issue is whether higher cutoff marks can be fixed for a reserved category.
That is the only issue, Lordship.
There are three stages. First, written test, then physical test, and second is interview. Interview is only for 10.
All right, let us not use the expression cutoff marks. Can the yardstick for recruiting a reserved category can be higher than unreserved category at any stage? Forget about the expression of cutoff marks. Cutoff marks not in the final, not in the written. That is immaterial. The point is they are all writing the same test.
Okay.
For some, you will keep the yardstick at higher when they are in a reserved category.
Your Lordship, whatever he marks he got in the preliminary test, if I give him 10 marks more, for giving one example, for interview, then he did not qualify.
We are asking you a very simple question. At any stage of the recruitment process, when all the candidates are writing the same paper, can the yardstick be kept higher for a reserved category than unreserved category? Whether at written stage, at the interview stage, or whichever stage, can it be kept higher than unreserved category?
On 16th, chairman completed the question. Third times candidates were fought for. That's why he did not qualify.
Mr. Mukherjee, you come to page 78 of the paper book. This is permissible.
OBC bearer, so far as this point is concerned, this is not at the final stage.
How many times you will say that you have finally said that it is not at the final stage? The query remains the same. At any stage, yardstick for evaluating a reserved category can be kept higher than unreserved category.
But depends upon the how many candidates are to be called for interview. 12 times.
Then let us see some judgment which says if there is a large number of competing candidates, then yardstick for reserved can be higher than unreserved. Show us.
No, not that.
What are you saying?
Whatever the total number of vacancies, what are the number of candidates applied for?
So therefore we said if there are a large number of applicants, then reserved can be judged by a higher yardstick than unreserved category.
Here, so far as OBC B is 80.5, at a particular point, that is at written test.
Huh?
That is at written test. Written test is not the final. Finally, is the written test interview.
So show us a judgment that at written stage it can be higher than unreserved. Come, where is the judgment? Show us. Kind of submission you are making. At any stage of the recruitment process, a reserved category candidate will have to qualify on a higher point than the unreserved.
If I give, for example, more that.
No, for no question of any example. The issue is, this is the only question. What does the law say? You can keep a qualifying marks higher than unreserved category.
Kindly see for a moment. He is a OBC B. OBC B for the selections of a candidate in a recruitment process of forest guard. But today, after the judgment of our High Court, after all candidates of OBC A, OBC B has been declared to be ultra vires. Now SLP is pending before the Honorable Court. Now SLP is pending before the Honorable Supreme Court.
That's not the issue.
No, but today
that is not the question. Question is, can a qualifying mark be kept higher for reserved category than the unreserved category?
Whether we have justified in 80.75 and 76.25.
Yes.
General candidate.
How do you justify? On what rationale? What law? Which provision enables you to do this?
The board adopted the resolutions to call for 12 times candidates. That's why this marks were.
So it is good. What you have done is good.
No, so far as, but ultimately.
How you are justifying, we are asking you. We are not asking you what has happened. We know what has happened. That you are saying, how do you justify this?
As far as this 2019 is concerned, fixing a cut-off marks higher than the general candidate.
Yes.
Only the question.
That is the only issue, nothing else. Yes. Because this candidate is excluded from the recruitment process, because according to this document, prima facie issue appears, he or she has obtained less marks than, he was required to obtain higher marks than unreserved category. Although there is no dispute that he or she is a reserved category candidate.
But these cut-off marks fixed on the basis of a number of candidates if qualified in the
Fixed on?
1:12 candidates.
So then it is permissible. From now on, state will do this. We will write that wherever there is large number, the state.
At the final stage, selection process completed.
That also you have submitted. So justify that it is permissible. We are not asking you what you have done. Don't just say what they have done. We are asking you, how do you justify this action? Then you keep a yardstick of 98 marks for reserved category and 80 for unreserved, and then you give 10 marks in the interview. They will all fail. There will be none from the reserved category.
No, ultimately we have.
So you want to do this? The state wants to do this?
No, not.
Then we'll record this. The stand of the state.
General candidate is always high. Not
always at every stage. Always means at every stage. So therefore, how at the written stage you have kept the yardstick higher for reserved category? Is it the state stand that they want to do this in every recruitment process?
Normally, we take the.
We are not on normally. We are on page 78. This is what you want to do from now on.
I'll take it next week so that I can affirm.
The short issue arising for consideration is
Full, my lord.
Nisha garu. Na. 15.
Yes, your lordship. I appear to the proposed respondent numbers 1, 4, and 5, your lordship.
1, 4, and 5. How
Pursuant-
many respondents are there total?
Pursuant to earlier order, we have served this application upon the proposed respondents.
1, 4, and 5.
While this
And why not 2 and 3?
already
Why separate councils are appearing?
lordship, the proposed respondent number 1 is the second wife of the petitioner, and 4 and 5 are the respondent number 1's daughters. Daughters from the second wife.
Respondent number 1 is second wife.
Your lordship.
Respondent number 1 is the Joint Secretary Public Works Department.
I apologize, your lordship. The proposed respondent number in the can. Respondent number.
So all are now represented. No, so now all the respondents are representative. You are for 1
1, 4, and 5.
and you are for 2 and 3. So 1 to 5 all are represented.
The can has not been formally allowed.
Hmm?
So, lordship, this application has not been formally
Where is the application?
can 1 of 2025. Khan has made this writ petition, and during course of argument, lordship, it fell from this bench that there is a mention of another woman, which, lord, allegedly the deceased was staying with another woman. And lordship was pleased to direct us to intimate that person. We had filed this application to bring her on record, and she is appearing today. She, along with my mother has also been implicated.
Who is 1?
Lordship, I think it's better if lordship takes up this letter from which the name of this it appears. It's at page number 14 of the writ petition, where my mother, Madhavi Das, she says that her husband used to live with another woman. It's at page number 14. She is this Rina, and her name is also mentioned there. In Katakla, Bengali language. 18, oh, page 14. But I am told that there is translated copy has been given.
You have given a translated
I am
copy.
told by my advocate on record.
Where? You have filed it or you have just
But I'm told that it's been filed. And it was filed in the court itself.
What is the date of this? 21/3/16.
On page 16, the date dated 21st of March 2016. At the third last line. Date is written in English.
Translated copy. Yes, translated copy is there. A can has been filed.
And one allowed. Item number 16.
It's me. কাকে বলছো জয়কে বলো ওনাকে বলে
Please use the mic.
আরে মাইক
Please allow Passover because he is arguing at court number 3.
Not today.
Item number 17.
Item 70, Mr. Kolal Vasu is for the petitioner, my lord. My lord, he is on legs before another court, my lord. Kindly make it not today, my lord.
Yes, not today.
Next week, your lordship. Right. Not today, your lordship.
Why, sir?
State council is not here, your lordship.
So tomorrow he'll be here, not today.
As it.
Item 18.
18 also, my lord, Mr. Basu is there for the petitioner. 18, in item 18 also, my lord, Mr. Basu is for the petitioner. Kindly make it not today.
Yes, not today.
19.
What is that?
Affidavit reply, my lord.
Yeah.
My lord. My lord, I am praying for short passover, my lord. My senior is engaging in another court is fixed matter is there, my lord. My lord, I am praying for short passover, my lord. There is a fixed matter that the reason, my lord, my senior is not able.
বাইরে দেখে নিয়ে গেছে
It's for the state. You are for the state.
Notified vacancy, somebody does not appear. Then mother just to the next.
Come to the second page of the advertisement. Yes.
Qualified.
So why the PWD seats have not been treated as unreserved? That is the only issue. If this is the terms in the advertisement, Then why it has not been done? What have you said? Where is your reply before the tribunal? State government had filed any reply before the tribunal? No.
It's not directed,
No, before the tribunal.
not anything is filed, my lord.
Neither state nor board.
Not.
But the commission has also not filed.
Direction was there, my lord, that is.
What happened to those vacancies? Cannot be. Only after that exercise in the note is undertaken, then it can be taken to the next recruitment process. Hmm? So therefore, what is your stand? That is what we are asking you. That panel was valid till 24. Yes. What did you do in the meantime? Did you, because see, if it is a vacancy under the PWD category, first, if there is no candidate available, then it has to be interchanged. There are various categories and the PWD reservation is meant for a particular disability. That is not, it is, the PWD is interlocking. It will, wherever it falls, it will, but then the nature of disability is also marked. So if they are not available, then first there has to be interchange between the various category of disability. After that, if it remains vacant, it has to go to the unreserved. This is what your advertisement also states. What have you done? Their case is that whatever has remained, you have not filled up. How can you do this? Huh? 83 are vacant.
No.
How many? 83. So if you minus 6, it will come to 83. Therefore, we said 83. You file a report. Let them file a report.
Opposition file, my lord.
Opposition is not filed by them. That is perhaps filed by the commission. That is why we are asking. Because commission says we have done the terms and conditions as per state. Let them file a report. The issue arising in the course of consideration which we have seen.
Item number 20.
20.
Why, sir? Out of station. Tomorrow with not today. Tomorrow it will appear with not today.
21.
Directed us to file the translated copies on affidavit of the vernacular documents that was supplied with the affidavit in opposite. Page 31 এ ডিভার্সাল অর্ডারটার জন্য কাটিকুটি ডিভার্সাল অর্ডারটা আছে সেটাই চেয়েছিল সেটাই সেটা দিয়েছে স্পেশাল হয়েছে ঠিক আছে পুরোটা বলা নেই হ্যাঁ Okay. I didn't understand. Thank you. Item number 1. আপনার কাছে সার্ভার হয়ে গেছে হ্যাঁ প্রভিডেন্ট ফান্ড বাকিগুলো পাবেন তাই তো দেখা গেছে সেটাই বলেছিল প্রভিডেন্ট ফান্ডটা দেওয়া হয়েছে অর্ডারটা এনেছিল কিন্তু অর্ডারটার মধ্যে বলা আছে
Yes. The petitioner dismissed from service 13/11/2016. 30th September 2011.
11, yes.
Of this page. At page 30.
Page?
Page 30.
Yes.
Against that, my lord, petitioner paper apps.
Huh?
Paper appeal under the
Yes.
Act. Police Regulation Act 1943. He paper appeal before the DIG. and law police. Then, my lord, petitioner page the DIG my lord passed the order. If condition he will join, my lord. Not page I am placing DIG order 54.
The period from dismissal to your joining was treated as not in service. Huh?
Yeah.
The order is there at page 54.
But the page, my lord. Page, my lord, 54.
Yes.
There, my lord. What order was passed, my lord? Your lordship kindly see. My lord, there are second, my lord. Having perused the proceeding file, appeal picture, collect the documents, and the general character of the appellant, and after applying my mind, I and state authority set aside the final order of dismissal passed by the disciplinary authority being such and such. The appellant is reinstated service on 13/9/2011 aim and date of dismissal, but he will not get any pay or any other remuneration for the period since the dismissal from the service till his rejoining, and the same will have effect on his pension and retirement benefits. The other portion of the final order regarding unauthorized absence of the appellant for total 314 days will remain as it is. As the appellant constable, as per his own admission, his total lost his utility in the public service. The disciplinary authority is directed to proceed with the PR of the appellant for voluntary retirement shown after his rejoining in the service. So, according to my lord order, petitioner joined. Joining order, my lord. Joining my lord 55. He joined. He joined, my lord. 55 page 55. He joined. Cross salary, man. My lord, he during the period, my lord, he again, my lord, absent. He was suspended, and again, my lord, moved before this honorable court. Honorable court already, my lord, regularized his service with conditions. But my point is short point, my lord. Again, my lord, petitioner on the same point, my lord, keeping pending the voluntary retirement application, which has been forwarded by the same disciplinary authority and keeping pending. Then, my lord, after that, my lord, he again dismissed from service. When, my lord, 315 or 314 days already absent, has been joined, my lord. My lord, again, my lord, proceeding and voluntary for.
What is the date of the charge memo? What is the date of charge memo?
What is the
date of charge memo?
My lord. 53 page, my lord, charge. First, my lord, proceeding.
53.
Page, my lord, 53 page.
53 is not the charge.
Page 25, my lord, it is first. You was dismissed from service.
So this is of 13/11/2006.
Yes.
No, 13/11/2003.
My lord, he already, my lord, dismissed.
What is the date? What is the date? of the charge memo.
Date of proceeding, my lord, 13/11/2006.
6
Proceeding was initiated
cannot
in
be.
the petitioner. Then, my lord, he was dismissed from service on 30th September 2011. Therefore, he preferred appeal according to law, my lord. The Petition Act 1943.
This charge is of 13/11/2006.
Absent. He's a cancer patient. Petitioner is a cancer patient. He absent.
Something wrong.
Naturally, not regular is his service.
What is the period of unauthorized absence? There are two periods. One is from 16/11/2000.
For total 340.
From 16/11/2010 to 30/12/2010. And then from 1 to 2011 till date of the charge memo. So if the period of absence is from 1st February 2011, then how charge memo could have been issued in 2006? 5 years prior thereto.
My name is my printed application has been forwarded. I have kindly seen the reply. In the reply, my lord, when I have been, my lord, already, my lord, forwarded my. May I just page, my lord, 26 of the reply, my lord. Area of lordship, my lord. My lord, kindly page 26.
Yes.
Service, W. Bardwan, 53, 2011, I talked to her.
Yes. Second paragraph. Yes. Yes.
But he was reinstated in service by the appellate office effect from 39 to
2011. Okay. So thereafter, then again there is absence.
He joined, my lord. He ordered us to join.
So then what is the date of the charge memo thereafter?
Bottom below, the period of suspension with effect from 5/12/2012 PM, each 4/2030 PM is confirmed and you will not get it. That is the date. Absence period, 16/11/2010, 30/12/2010 AM and 1/12/2011 to 11/3/2011 in charge frame date.
So that is the charge. That is the framing of charge. That is what I was asking.
That's what I'm saying, but only this page will suffice. It's already been decided and in the final order passed by the
No, then
already
what is your prayer before the tribunal?
the tribunal, my lord, he paid, my lord.
Next.
He wants squashing of the entire departmental proceeding. He has.
Last operation, last order, already short point that there was with regard to benefit area dues and other what
already paid.
Now, my lord, in terms of that, my lord, by an order dated 16th April 2025, that is the last order of his lordship. Take note of an aspect of the matter regarding the petitioner's claim for being made available his deposit lying in the provident fund account bearing the person and insurance as well as other dues, and the instant affidavit is being filed. In terms of that, the affidavit has been filed, and in this affidavit, lordship find from this paragraph has been declared from the circuit. In this I have chronologically discussed with regard to all the facts, date wise, from what is happened from but ultimately it's there in position. in 11I a synopsis was given. Today's affidavit which we have filed today, my lord. It has been the
Translated documents. Again, affidavit.
the affidavit was dated.
Oh, already filed.
Already filed. Second of July 2025. Affirmed by Miller 1 Part 2 law.
6B.
Now we start with 6I versus penalty.
Yes.
Prior there are incident and chronology of events has been discussed. In I Miller, personal was dismissed from the service page 11. 6I. From service in connection with the Bardwan district proceeding so and so, but was reinstated into service by the appellate authority from 39 2011 with a direction proceed with the prayer of the appellate for the voluntary retirement soon after his joining the service. But after joining the service, the petitioner denied to submit the same. The disciplinary authority cannot afford to show leniency time and again when the person responsible for such acts never showed any symptoms of rectification of misdeeds, rather employment or to indulge in such misconduct. Hence, after having no other options, the disciplinary authority had to believe that the petitioner has nothing to say about the findings of the Bardwan by the officer and show cause notice issued to him by the authority. The reply to the show cause is also not tenable to refute the charges which have been proved against the petitioner beyond any shadow of doubt. Thereafter, in terms of his lordship's order, we have calculated what views and dollars. If lordship kindly come to page 31. And similar regarding Miller, release of final GPF fund to dismiss constable Swan. Reference to the above mentioned subject is to apprise you that Honorable Swanso.
I am not disputing this point. Well, it's already paid.
That is the only thing that expressed by lordship order, whether with regard to the entitlement and
GPF and group insurance.
In terms of
all paid.
It's already paid, my lord. I have received, my lord.
Page 31, lordship.
I am not my lord disputing that.
33, my lord, kindly takes my lord. The details.
Only
What is the total amount paid? No, 201.
1,880.
Yes, and group insurance?
I think that has also been paid because at the time when we affirmed this at that point it was told, I'm not.
Well, I am not.
Have you stated that it was paid?
I am not because of the reason when this was prepared at that point of time. But over telephone.
Now you have instruction that that has also been paid.
I am already disputing not amount. Already received according to your lordship order.
Huh?
After your lordship order, I received the amounts, my lord. I am not disputing that. My only point is, my lord, when I applied for voluntary retirement according to order of the DIG, and also my order application has been forwarded. Kindly see the order reply in the, my lord. Kindly see the reply. My application already
What is
pending this application? I have been dismissed.
What is your prayer before the tribunal?
Page has been annexed with this declaration.
What is your prayer before the tribunal?
Not in the tribunal, my lord. Some of the advocate was there.
The prayer has been noted in the order of the tribunal.
For an order to issue credit thereby setting aside was evoking cancel withdrawing the proceeding order page 177.
Yes, there is no issue of VRS.
Only my lord, in the meantime, he has been retired from service. He is retired petitioner from the service on 30th April 2023.
What do you want from the court?
My point is short point. I'm arguing before you, lordship. Why, according to order of the DIG, I have applied for voluntary retirement. My voluntary retirement application has been forwarded. Keeping pending the application for voluntary retirement, the appellate authority, discipline authority has been dismissed. So this is the
Appellate authority?
already dismissed. After the receiving, forwarding the voluntary retirement application, your lordship kindly see the
There is no relief regarding voluntary retirement sought for in the OA. In the OA, you have not
pending by application.
in the OA, you have not sought any relief regarding VRS. Therefore, there is no question of relief of VRS. In the OA, see your relief at page 177. See your relief at page 177.
The paragraph 6I, which I referred to, lordship will find we have indicated, Lord. Appellate authority with effect from so at the bottom, Lord, page 11. I read, Lord. Appellate authority accordingly with a direction to prosecute the prayer of the appellant for voluntary retirement soon after his joining in his service. Thereafter, but
He has not made any such application. That I have read, therefore we are asking.
he has not made any prayer.
That is why in the OA also there is no prayer.
Already he joined service. When my lord, he already joined. Page my lord.
Again we are asking you. This is not a forum where you can say anything and everything you want. The OA you have prayed for quashing of the departmental proceeding up to the appellate order. You are not making any submission with respect to that. The dues which you are entitled, admittedly you have already been paid. There is,
I have a cancer patient. I could not continue my service. That is the only unauthorized absence. That is the allegation against me.
We are not the appellate authority. We are not hearing your allegation. In the OA, your only relief is for quashing of the departmental proceeding. In the OA, you have not sought any relief that your VRS should be accepted. Therefore, there is no scope for any such argument in this proceeding regarding VRS. This opportunity we are giving you, what is wrong with the disciplinary authorities order or the appellate authorities order. You have not made any submission on that before the tribunal. You are not making any submission regarding that before this court. Therefore, what is to be done?
My point is, my lord, only.
Your point, you can say anything that the petitioner was born on such and such date, but that's not relevant. Unnecessary waste. You are wasting the court's time.
I understand, I, my lord. There is no whisper with regard to denial of this statement of ours, my lord.
He has not made any denial. Therefore, we are asking him.
They have not, my lord, considered the case of the voluntary retirement.
Then nothing is to be done. The petition
record my lord my submission. The voluntary application already forward.
Nothing.
APDP.
All the next case.
22.
Please use the mic, sir.
But according to my lord, the
Paper book you have filed, that we have understood. What else?
I'm led by Mr. Pradip Kumar, the senior advocate. It is not here. My lord, kindly, my lord, makes it. And that is all my.
Tomorrow with not today. Will appear tomorrow with not.
Wait, item 22, my lord, I am appearing for the rest number 6.
It will appear tomorrow with not today. It will be taken up on Monday.
23.
I am for petitioner, my lord. That on last occasion, my lord's pleasure was, allow me to place some or rely some other judgments, my lord. After my lord, judgment of Satish Chandra Yadav, my lord. I have already obtained my lord 2 judgments, my lord. Govindra Kumar, State of UP, my lord. Recent judgment, my lord. Yes.
We heard you the other day. We did not hear you. The other bench heard you the other. So his lordship has not heard you.
I have placed it, sir. Appointment to the post of my lord, Law Division Clerk under the government of West Bengal. My lord, that my lord, he was asked to submit the police verification form. He has submitted the police verification form, but due to mistake, paragraph 13, my lord. Yes. Written, my lord. Not applicable. According to my lord,
There was a query regarding arrest.
arrest.
Whether you have been arrested. That was the query.
But so for pending case, whether any pending case is there or not, that was not the queries in the state.
Therefore, we are correcting you. It's not a question of case. It is whether you were arrested or not. You said not applicable.
Not applicable. Now, my lord, regarding that, my lord, my learned friend has relied to judgments, my lord. One judgment, my lord, Kumar. The petition has already been acquitted. My lord's pleasure was that whether the after acquittal is there any appeal against that acquittal or not. My lord, there was no further appeal against that acquittal. That I have, my lord, submitted by way of supplementary exhibit report to Honorable Court. And my lord, thereafter, my lord, another the query is, my lord, prior to this, my lord, petitioner has already approached before the learned tribunal prior to acquittal, my lord, disclosing that the criminal case is pending before the learned forum, my lord, and my lord prayed for appointment. My learned tribunal was pleased to dispose of that original application, the direction that the petitioner's right will be approved after acquittal. And against that judgment and order, there was no appeal by the state authorities. And now, my lord, after that, my lord, after acquittal, he has prayed before the authorities for appointment and considering his acquittal. My lord, thereafter, my lord, his PVR was considered by the authorities. In the earlier occasion, there was no whisper regarding that he has suppressed the facts regarding arrest. And my lord, other things is that, my lord, he also, my lord, already, my lord, prior to adjudication of his and or considering his PVR, my lord, that he has already submitted before the learned tribunal also before the authorities that he was arrested and his case was pending before the learned forum. Now, my lord, also relied upon these two judgments, one after things, wherein the honorable division bench, the judges bench, my lord, considered the entire views, entire aspects regarding suppression of facts of the criminal case, of pending or not, or arrest or not, my lord, and it was considered by the honorable apex court that if the nature of the case is trivial in nature, he can be, my lord, allowed for appointment. And my lord, in this case, my lord, the petitioner was, my lord, arrested and or, my lord, criminal case was pending due to, my lord, in a case under section 498A. And that case was registered initiated by the daughter-in-law of the petitioner. He is not involved actually, my lord. But since he was the member of that family, his name was, my lord, implicated in that criminal case. And, my lord, thereafter, my lord, he was acquitted subsequently. Now, my lord, my prayer is that, my lord, my learned friend relied upon the judgment after seeing judgment. And now I have find out, my lord, judgment, one Ravindra Kumar versus state of UP and others, that Satish Kumar Jadhav was considered and by the court, honorable apex court, and direction was given for considering the appointment of the petitioner, of that petitioner, my lord. This case is same, and, my lord, another judgment, my lord, of our state, my lord. Let's see. Paragraph 26, my lord. The other was right upon, my lord. Paragraph 26. Judgment of 24, my lord, and that Satish Jadhav was decided in the year 2022, my lord, 2022. Ravindra Kumar. No, no, Ravindra Kumar.
Yes. What helps you from Ravinder Kumar's judgment? What helps you?
Satish Jadhav was considered
Applied.
applied.
So what is the, which portion of this judgment helps you? Which paragraph? No, 26 is nothing. In 26 there is nothing. It is just consideration of these earlier judgments. Yes, 31 helps you. Of this case. Therefore, we are asking you how it helps you. After considering the judgment of Satish, the apex court says you see page 31. In our opinion, page 32. On the peculiar facts of the case.
In nature, tribal in nature.
So Satish Chandra has to be applied. Satish, this is not a departure from Satish Chandra.
Particularly, it was considered if the case is in tribal in nature and if there is no moral turpitude, my lord, in that occasion, my lord.
Where? Show us. Read that portion.
The moral turpitude concern of analyzed judgment was passed by the Honorable Apex Court in Nitul Kumar Jana. These pending cases.
This is after Satish Chandra case.
But they had petition for judgment of 23. Since there was no stipulation regarding pending, so
then why you are giving these judgments which are not on different facts? Why do you give the judgment? In your case, there is a requirement to disclose whether you were arrested or not. In there is no column. Why you are giving that judgment?
There was also column that whether arrested or not. Paragraph 9, arrested, detained or convicted by a court of any offense. The answer is yes. In particular, of the arrest or detention or conviction of no. This is it. But whether since there was no stipulation regarding pending cases, whether there is a pending case or not, that it was considered allowed by the last option.
How do you rely on such cases which are on totally different facts? You are appearing for a party, you should go through the facts, not throw every judgment to the court, whether relevant, irrelevant. Why you give irrelevant judgments?
There is no stipulation regarding whether.
Don't make submissions like this. It doesn't help anyone. It doesn't help your client also. Why should you make such a submission? There was a disclosure required whether arrest or not arrest. That is the only thing. And see what in paragraph 10, what the apex court has noted. He is not required to furnish information. Here, that is not the case. Here you have given a wrong declaration. NA. Unnecessarily throwing every judgment at the court. Knowing that it is not going to apply, still you are giving the judgment. Why should you give such a judgment? So therefore, we should take that judgment also. No, in this case, why you have said NA? That is the only issue. Why you have said NA? Correct. That is there. That is, the other facts are totally different, sir. This does not apply. You must have seen.
The consideration was there whether if the case is trivial in nature, that the petitioner
Again and again, we are asking you from Ravinder Kumar, show that if case is trivial in nature, it should not show that portion. We are unable to find, therefore we are asking.
paragraph 20 of 30 was considered.
Please show that the judgment of Ravinder Kumar, the apex court has said that if the case is trivial in nature, it should not matter. Its non-disclosure will not be having any adverse effect on the candidature. You are arguing that this is what the judgment says. So we are saying show from the judgment where it says. Paragraph? No, wait, we'll go through it. You need not read. That's all. Yes. You have seen these two judgments which are being relied.
But a kind of thing. Admitted position is that yes, by the application here form, that there is no error. There is a suppression of that.
No, he has not said no arrest. He has said not applicable.
Not applicable. Not applicable, but either he has been arrested, nor he has been criminal case is pending.
No, that is not there is no requirement of disclosure of any criminal case. Only whether he has been arrested or not.
Hundred and four.
104.
Have been arrested, detained, or convicted by any court of an offense? If the answer is yes,
Correct. So there is no requirement of disclosing the case. Only whether you have been arrested or not.
arrested or not. He has said not applicable.
Not applicable.
Admitted position, he was arrested.
He was arrested. That there is no dispute. He was arrested.
And on the basis of that, this forwarded to the police department. They have forwarded a report to the that there's a supply. Kindly see the order pass. Page 92. Don't you got it? The undersigned is directed to refer to your memo number such and such dated 21st, 2015 and memo number 3rd June 2015 on the above mentioned subject to state that the government considered that Narayan Patidar unsuitable for employment to the post of road division clerk under Department Food and Supply, Government of West Bengal.
No reason has been assigned why unsuitable. Why unsuitable? Read from
Unsuitable. But no
why?
reason.
Why from that letter? What can be made out? Why? What is the reason?
All these two documents, this is the criminal case. All these two memorandum.
This is without any reason.
No reason. Only no reason to because this is the document relies upon on the basis of this that
Where are these two documents? 21 2016 and 36 2016. Where are these two documents?
And if you put it. Now page 74, can you see? 74 and 75. The undersigned is directed to refer to your memo dated 2094 and dated other subject that government Narayan Patidar unsuitable for employment post or revision on the food or supply. The next verification, page 75. This is to inform the government consider Narayan Patidar unsuitable for the post or division clerk under the Department of Food and Supply. The government conveyed these decisions by memo dated 12 July 16. Copy of the government order is original BR is returned with memo dated such and such. Then
74 and 75.
yes, BR was returned.
No, this is not 24. 74 is not the document.
75. Verification role.
75 is which? What is the date of this document?
23rd July 2016.
23rd July.
23rd July 2016.
Sir, this page 92, you said it is relying on two documents.
No, that is a page 75 is memo dated 23rd July 2016.
Page 92 is the rejection order.
Yes. No, on that, after that, this here was again forwarded to the government.
Huh? After this document of 12 July to 16.
No, sorry. No, this is 22nd June 2016, but 23rd July 2016. This why this was page 75.
Where is the order of rejection? You find it. You find it.
Call that first.
PPM matter item number 108. That's my appeal, my lord. Appeal against an order passed under Order 21, Rule 97-98-101 of the Code of Civil Procedure, my lord, where I am the decree holder. And my lord, the rights of a third party has been identified and the decree is sought to be, my lord. Now, my
Your
lord,
Lordship, I am appearing for the respondent number 1. The only issue is, Your Lordship, the impediment that I am having. Your Lordship, I am being led by Senior Advocate Mr. S.N. Mitra and my senior Mr. Shomure Chaudhary. Both of them are not available. The advocate record also is not available. Our entire team is not being able to be available today because it was supposed to be listed on 4th. My only request is kindly give us a short date, Your Lordship, because even if they start, the issue would be if we come.
It was supposed to be listed on 4th.
Yes, Your Lordship. But due to continuity, I guess it again got listed today. My only request is the continuity would break, and we don't want to cause any trouble to Your Lordships.
Give an agreed date. Give a date which is convenient to both.
next Tuesday, 11th, my lord, if commences to my lord.
November.
Just keep it after the coming week.
Your Lordship, 28th November can be
18th.
18, 20th. She wants 20th.
28th.
20th.
I get it, but none of the seniors would be available. We cooperated a lot because they took adjournment on three occasions.
My lord, we are supposed to start 20th, my lord, if my lord.
20. 20th, you are also saying.
Tuesday is 18th, my lord. Tuesday is 18th.
18, 19, I'll be in Bombay. I can't.
20th is Thursday. You can start on 20th.
28.
20th.
20th.
20.
Grateful, Your Lordship.
Zero.
I totally grateful.
On account of
Grateful, Your Lordship.
Continuing matter item number 23.
So what are these two memos? Where are these two memos? 21, 2016 and 3, 5, 16. Page 55. So that is at page 75. No, page 74. How can it be challenged? This is interdepartmental. Yes. No, see at page 75 at the top left corner it says confidential. Yes. So this is the 74 is not confidential. What you are trying to say? Where is the rejection order? By which order he was communicated that he is unsuitable? This was not again we are asking you, by which order he was conveyed that he is not suitable? Huh? So where is the communication to him? So there is no communication to him regarding his being unsuitable. So there is a presumption that it was communicated. Then why we are asking you whether you have communicated to him any decision that he is not suitable, and for what reason? Again we are asking you whether you have communicated to him any decision that he is not suitable and why. There is nothing. No? No, we are asking you. You have to satisfy us. We are asking you where is the communication to him that look, for such and such reason you are not suitable. There is no communication. So therefore he has himself challenged some intra-departmental communication that which says he is not suitable. Please, you sit down. Where is the order passed in WP number 5953 of 17? 76. And the order passed in WP 29605. 29605 of 2016. All right, then OS 751 of 17. 751. Yes. So no rejection was communicated. He has stated in his way. You said he has not stated. He has stated. No, there is no communication. That is an instruction sent to the state council. That is nothing. There is no communication. Page 76. That communication was part of the statement. And only when it was received by him, then he has challenged subsequently. Tribunal has considered anything or not considered? Can not make it. 12-7 is the only order. Twelve seven is the only order. There is no other order. 12-7-16. That is the only order. The one which is at page 74 or 75. No, only one. 12-7. That is the only communication. That is nothing. That is not communicated. Hmm? No, but that issue, he has raised that issue in the tribunal, saying that my nothing is being done. Before the tribunal, he said, I don't know what is going on. In the statement, you gave that 12-7-16. Then he said, I will challenge this. Maybe. So you are raising a point that it has not been challenged. Page 75. This was enclosed by him in the OA. Which annexure number? We are asking him. But in the prayer, there is no quashing. You will not allow him to make submissions. You don't want us to hear the matter. For everything he says, you have to stand up. No, that we have seen. 75 is. Very well. Heard the parties. Is
Keep this properly.
And 24.
State led by Sonal Sinha. She is due to health ground. I am praying not this week.
your reply? Where is your reply? You are given time for file.
Reply is not needed.
You are not filing. Is what do you want?
Everything has been disclosed by
What do you want?
Not this week.
Why?
This matter led by Sonal Sinha. She is health ground not present. That's why I'm saying.
Tomorrow with not today. It will come on Monday.
Much obliged.
Your lordship kindly make it in the top of the list.
Call the next one.
25.
Last direction was to file the affidavit of opposition, my last direction is affidavit in opposition to file.
You have filed opposition.
But I seeking for 1 week time to file the opposition because it was to go to the for vetting or to the department.
The time for filing opposition.
Twenty-six.
Pleasure, lords. Are the matter at rest, but not clear matter. So may I just recapitulating what I have stated earlier. But the petitioner is a doctor and appointed in 1988. How the time around a problem cropped up, that comes with the topic is at that time, the petitioner moved on a tribunal, and as per order of the tribunal, he was studying in the cell. But 2009, 2011, they are paid. After 2011, salaries have been paid, but since 2009, there has been no incremental benefits. Now he is getting only the petitioner again moved the tribunal. The London tribunal passed an order that the authority would consider. My lord, that initially, my lord, an order was passed in 2020. And our subsequently, almost same order has been repeated. If your lordships kindly look at page 68. 68. January 2020. So this consideration was made as per order of the Honorable Tribunal. May I read out, my lord? And this problem is, my lord, continuing from 2011. Whereas the Honorable WBAT was pleased to observe on December 19, 2018, that this is disposed of by granting liberty to the applicant to file a representation ventilating his grievances with regard to area salary and service benefits, annexing of the relevant documents before the Director of Health Services, West Bengal, the respondent number 1B, within 4 weeks after having a copy of this order. If such representation is filed within this time, as stipulated, the same shall be disposed of by the Director of Health Services by passing a reasoned order to be communicated to the parties within 10 weeks after giving an opportunity of hearing and after verifying the records and documents. And whereas, in compliance with the said Solomon order of the Honorable Court, the applicant was called for hearing such and such day. The applicant attended the hearing then. Whereas the applicant contends through his representation dated January 2022, 19, that Dr. Islam was working at Harampur PAC under Islam Rural Hospital, Murshidabad, and was getting regular salary from there. He contended that from the period 2009 March 11, the salary was stopped. There also contends that again from September 14, 2014 to May 15, and for 9 months, the payment of his salary was withheld. However, it was contended by the applicant that from June 2015, the salary was being disbursed as usual. And whereas the applicant also reiterated that in the said during the period from September 14 to 2016, he was very much on duty as well attending lecture. The applicant suggests that since August 2009, no incremental benefits had been given to him. The petitioner informed that owing to not joining at the Indrani PAC Calcutta and on from March 17, payment of salary is stopped by the authority, but ultimately he had joined at Indrani PAC on January 10, 2018, and finally he contended that the salary from August 2000, March 11, and from September such and such was due. And whereas it appears from the available record that when he was attached to Harampur PAC and Islam Hospital, Murshidabad, he was remained absent from duty from August 5 to 2009 to August 89. These are the dates of unauthorized absence. And whereas it appears that the side has issued a so-called notified letter such and such asking him why disciplinary action should not be taken against him for the reasons. Dr. Ramakanto Mujumdar X, PMOH Islam Hospital issued a RIF certificate, Dr. Islam. Dr. Bazul Islam, during his unauthorized absence, period B, and that is Dr. Ramakanto Mujumdar issued a letter that there was no question of overdraft. Dr. Islam, as soon as audit report of 2016, which was a contradictory opinion. Now, therefore, after careful consideration of the entire gamut of the case, the understanding is of the opinion view that since the local authority, PMOH Islam Rural Hospital is yet to reply regarding unlawful disbursement of the salary in the tune of 13 lakhs and odd, hence at this juncture, there is no cogent reason of giving any relief to the petitioner right now. Local authority was also requested to file regarding the entitlement of petitioner's claim. After obtaining the reply of PMOH, we should issue final reasoned order. The case is disposed of. Then, my lord, the next page, page 70, kindly see, I being the block medical officer of health, Islam Rural Hospital, to hereby declare and say that Dr. Bazul Islam, additional medical officer of Harampur, was regular in service. He was not absent during the service tenure in his hospital as has been shown and projected by the higher authority in this report. If the attendance register of the relevant period is looked into, then examined, the amount as alleged absence of Islam was shown in the report and contrary to the records. There is no question of overdrawal as shown in the report. He is entitled to get a huge amount of arrears salaries, which has been illegally withheld. Official mistake. Now, my lord, then we find the petition in this honorable court as the order was not. Kindly look at page 71. This is my lord, Mr. Justice Harish Tandon and Rabindranath Samanta, as their lordship was there. The director of Health Service directed to submit a detailed calculation on the entitlement of the petitioner, which is claimed to be the instant writ petition. According to the petitioner, the challenge, we stand on the same legal pedestal that of other of the petitioner are getting higher amount per month than the petitioner. Let us let the matter be listed on December 2021 to enable the authority to produce the documents before this bench. Because when I am getting only 80,000 or 90,000. Others are getting on a double. Now, page next to 72. Despite the direction passed, and Mr. Thomas was also there at that time. Despite the direction passed on December 17, 21, after the Director of Health Services to submit a detailed calculation on the entitlement of the petitioner, which he claimed in the instant writ petition as observative, elaborative disbursement pertaining to the by Mr. Thomas advocate for the state, which he received from the said director. There is no hesitation in our mind. The same is not in the tune with the direction passed December 17, 2021. Let me say, kept with the record. However, after hearing the parties, we feel that they are not actually, more particularly on this unauthorized absence as projected. But in view of above, we feel that the matter is required to be decided upon exchange of affidavits. An affidavit in opposition to this month, it was not complied with, but there was an affidavit. Then, my lord, with this change of bench, matter went before another bench, and then, my lord, this order was passed, page 74. Was again relegated to the, my lord, before the landed tribe. Now, we made the, my lord, representation as per the order of this honorable court. Now, kindly see, the Director of Health Services, without hearing the petitioner, formed a committee and asked the petitioner to appear before the committee. Some question answer given. Kindly look at from page 81. I earlier submitted, but on repeating. From page 80 onwards. The committee was constituted. The director did not hear the petitioner. On October 16, 2023, name of the officer with designation. Then, date of joining, March 10, 1988. Present place has been given. Where you had been stayed at Harampur, Asia under Islam Hospital, in charge of the PhD for the period from 2009 to 2011. State briefly. Yes, but transfer as per order of the PMOH. Whether you have visited, I am it's bit difficult due to my spectacles. Whether you have discharged your duties perfectly. Yes, of course. Then, these are the malad absence they have shown. Query, no. Whether your absence from the duty was with prior intimation from your higher authority, head or office, yes. And you applied for leave, yes. If your answer is no, then why your absence from duty shall not be treated as does not arise, not applicable. Whether you can receive monthly salary time, state the reasons briefly. The non-cooperative from the continuum intentionally done. Then, my lord, as per the acquittance rule, salary of Dr. Bozislam from the period from August 2009 to October 2009 had been drawn by your office from the government exchange from time to time. But later on, the salary for about 3 months was ultimately deposited to SBI Government. But this I would explain due to the lesser amount, because at that time he was paid only rupees 25,000 instead of, my lord, 1,50,000. I advised him not to accept because he is not a beggar. I was offered only 20,000, 25,000. So he refused and salary went back. Whether there are any other instances of inquiry in the circumstances? No. Whether we have any more addition on this issue or in your state briefly with supporting documents. Wrong. The handwriting is not the same. Answer regarding place of posting. Work in different places, Khordram, PHC, from July 4, 2007 as additional medical officer. Indrani, period from March 12, 2017. Beldanga, Indrani, then Chuan Roger. Answer against question number 15. Letters have been addressed to Murshidabad. When I received some letter from such type of letters the letter is by the DCMH, Domkul, by such and such. Received and such type of letter from the ACMH Domkul and also BMH Islamabad. Now, I kindly see the authority on the basis of that report. The order was not passed in time. In my lord, I have filed a contempt application. Passed in such contempt application. My lord, kindly see the page 87. Order dated. Rescind order in terms of the order of the Honorable High Court, dated June 19, 2023. Was directed to be done within 10 minutes. Now, my lord, this is a lengthy order, almost repeating the earlier stand. Page 189 is relevant. But now it is evident from the report submitted by the constituted inquiry committee. Dr. Bozislam had failed to justify his stance in the instant matter and had been on the unauthorized leave from duty on several occasions. Moreover, the petitioner has also attempted to mislead the inquiry committee by furnishing the fabricated document by tampering attendance register. My lord, the attendance register was never produced. Nobody has seen the attendance register. It is within the custody of the authority. It was not in my custody, so there is no question of tampering by me. In order to be stance, the undersigned has scrutinized all the relevant aspects of the matter and hence the conclusion that Dr. Fazlul Islam, the petitioner, on account of his unauthorized absence from duty, has overdrawn salary of rupees 13.4 lakh from the department. Same earlier order has been repeated. It is ordered that the said overdrawn amount be recovered from the petitioner at the time of the settlement of retirement benefits of the petitioner. The case is disposed of. Now, this was challenged before the tribunal. The learned tribunal, my lord, has rejected my prayer, holding that there is nothing to interfere with. Hence, this is the impute order of the tribunal is at page of 3 pages, page 108. Page 100 and my lord, 8. The matter is taken up by the single bench consulted application file session, sir. In short, the applicant, a medical officer posted in the district was issued show cause letters. My lord, I have categorically stated no, never any show cause letter was issued. Not a single document they have annexed. The reason order explained in detail the date of which he was on the absence, which was inquired by the inquiry committee. The inquiry committee had submitted its findings, report dated January 1. The inquiry committee, the director of health services, and passed money of service. That's over from amount through salaries to be recovered from the applicant at the time of settlement of the payment due. Mr. Mustafa Lanet accounted that the applicant had never been served these so-called notices. Further, Dr. Ramakanto Muzumdar, in his supervisory officer, has issued a letter stating his satisfaction that there was no chance of unauthorized absence. Therefore, the question of overtrail does not, as pointed out by the authority, is not valid. Having heard submissions from I have not find that the applicant, Dr. You had remained absent for several days, as pointed out in the findings of the inquiry committee, and the reason not. To respond to the specific question, the inquiry committee was also doubtful some of the record presented by the applicant to cover up the absence. Which he applied. From a proper examination of the records, it is satisfied that the tribunal had the applicant was absent for various periods. 3 weeks around PHC under Islam Rural Hospital, submitted by the inquiry committee. The defense statement of Dr. Ramakanto Muzumdar, the PMHO of Islam Rural Hospital. Accepted by the learned tribunal. Now the question is, my lord, my whole case is I was never issued any super. Be that as it may, my lord, if I were absent for some time, my salary has been given less, but incremental benefits in my incidental of service, that has not been considered. That was directed to be considered by the on various occasions by the learned tribunal. Issue is, my lord, the granting of incremental benefits. My other colleagues, similarly, they are getting 1,90,000. I am getting only 90,000. Now here, my lord, and my lord, before the learned tribunal, they did not place single document or in 1921, I was due to retire, but the change policy of the government is still now in service and going to retire after 2 or 3 years. Now, my lord, here the main ground I have taken. I want to clear that
this reasoned order of 15/4/24, you have challenged it before the tribunal or you have challenged before the High Court also?
Before the tribunal. And that tribunal order has been subject of challenge here.
Yes. What is the challenge is on what grounds?
The learned tribunal did not.
The challenge is on what ground? this reasoned order of 15/4/24, why you have challenged? What is wrong with this order, reasoned order?
The reasoned order is unreasonable because the reasoned order is the repetition of the earlier order. Earlier order, my lord, which was passed in.
That was passed on 24 January 2020. 2020. Yes.
Observing that after getting the opinion from the superior authority, they would decide.
Yes.
The superior authority at page 90 may not give that yet he was not absent.
So because it is in the same terms, therefore it is bad.
My lord, my grievance.
We are asking you,
I am
what is wrong with this order of 15/4? You say it is repetition, therefore the same order if it is passed.
Because, my lord, the authority did not consider my grievances in its proper perspective. The issue is, my lord, since 2009, 2011, my area salary is due. They are quite silent on that aspect. And, my lord, they are quite silent on my incremental benefit.
No, there's no question of silence. The issue is some period, they say long period of unauthorized absence.
And
Therefore,
they may deduct.
therefore,
They can deduct. They can. But, my lord, since 2009, I am entitled to get my incremental benefits.
No.
That is the law.
2009, from 2009 to 15, you are absent for a considerable period. So
they have calculated that I have over rupees 13 lakhs.
yes.
Correct.
So that to that extent, you have no difficulty.
Difficult.
Then what is?
But, my lord, regarding withholding of increments.
So regarding increment, where is the demand in your second representation?
That is, my lord. Second representation.
Yes.
That is, my lord.
Cover the amount without any.
16. That is, I have. That is statement made before the Madad authority. Second representation pursuant to the order of the Honorable Court. Stay that way. Page 76 onwards.
Is there any order withholding his increments? No, to that he is not objecting. Then it is done. Nothing remains.
It's done. Earlier also I agreed. But, my lord, they would deduct it from my salary, 13 lakhs. But if proper incremental benefits areas are given to about more than 1 crore, that should be calculated and placed before the court. They will deduct 13 lakhs.
We are not at all concerned with calculation. We have no concern with calculation. That is not within the judicial review.
I have taken.
We will not look into calculation. We will not do that. That is not the job of the writ court. Sorry.
No, but, my lord, they are asking about my lord fault. But the fault which they have committed, they are not going to. The wrong they are not.
We wonder why they have not proceeded against you.
If I will dismiss.
They should have.
They should have.
Yes, but they have not done it. Yes.
But at the tag age of my career, I am going to retire the next.
We don't know.
Kindly see, my lord, of increments.
No, where is the question of withholding? There is no order withholding increment. Therefore, we asked him whether there is any order.
But they have not given.
They have not given. So they will consider. You pay that amount, then they will consider.
No, consider, my lord, they will never consider.
So what do you want? We should write the order in their place. Then what do you want?
Your lords.
After all, they have to do it. We can't do it.
My lord, question of bread and butter.
Oh, it is not, sir. We don't think so. From the reading of the representation and the sequence of events, we don't think so. It's not a question of bread and butter. It's a question of rights.
Rights.
Asserting rights. without performing duties. That is the case.
Lordship, your lordship. I am not dictating lordships, I am requesting submit.
Yes.
That
And the rights you are asserting because they have not diligently proceeded against you.
yes,
Otherwise, you would not have been in a position to claim 1 rupee for that.
if I have been dismissed ballot in 2011, I would have been in other.
So therefore, you can take the benefit of whatever you want.
Since 2015, I am repeatedly making the application that you give me my area salary and increment the.
No, they have said in the order that this amount they will recover at the time of your retirement, settling your dues.
But
So at that time, you will make your claim.
No. But they are totally silent on my incremental benefits and area salary. They have given a report, kindly see.
They have given a report.
Yes. July 16, 2025. So they should speak about my incremental benefits area salary. That's why I am requesting your lordship. In the last occasion, the submitted instruction. With reference to the subject mentioned, I have directed on behalf of the Department Health, Family Government. In terms of the orders and answers passed by the Honorable Court, a proposal has been sought from the department regarding the recovery of withdrawal amount. That amount. To be noted that a recent order on was passed by the United Health Services, West Bengal, wherein it was inadvertently considered already attained the age of superannuation, and it was ordered that the appropriate amount be adjusted from the retirement benefits of the patient. Regarding that aspect, I am happy. If I am entitled to get more than one floor, I have got 2 sons, they are medical students. I am in financial terms. Since 2015, there is no allegation. He is doing the job. The satisfaction of the authority.
Yes, why you have not taken a decision on the entire thing? Why you have not taken a decision on the entire representation? Again, we are asking you. We are not asking you what you have done. We are asking you why you have not done. Regarding his increment, why no order has been passed? In spite of the direction of the tribunal, when it is there, he has filed a representation. Why have you not filed any order, passed any order on his claim for increment and proper payment of salary? You have neither taken any steps against him, nor you have passed any order. See, he is not claiming any raising any objection about recovery because he has very calculatedly made a submission that he will benefit from this position. But the point is, what is the action that you propose to take? How you will resolve the issue? It has to be composite. At least it has to be composite. You take a decision on the claim for his increment, and then only you recover. If you take a decision that you are to pay him increment, then the recovery will also increase. Because the per month salary which he has drawn, we don't know. If you take a decision that no, we will not give him any increment, we will proceed against him, you proceed. But you must do whatever you do composite, not piecemeal. The Yes.
Extremely grateful. Actually, your lordship, my lord, I don't mind because I tried my best to convince your lordship that I have a bona fide case. Deprivation since my lord 2009. Maybe petitioner is to some extent fault also.
Composite decision, what they want to do. I have left everything open. Yes.
He's going to retire very soon. I'm extremely grateful, my lord.
Item number 27. Lordship, I am appearing on behalf of the petitioner. Lordship, I am appearing on behalf of the petitioner. In this matter, your Lordship, on the last occasion, your Lordship has directed the
Opposition is filed.
Oh, nothing has been filed. No, it is no about it. 28.
Lordship, Lordship, in item number 28, Lordship, I appear on behalf of the petitioner. I am led by Senior Advocate D.N. Ray, Lordship. Lordship kindly takes up the matter on Monday. He is not available today and tomorrow, Lordship.
Tomorrow with not today.
Great.
$29.
Which one? So no order has been passed on this representation. Has any order been passed on the representation? No order passed. They filed a reply before the tribunal. Why you have not decided the representation? We come to page 57. Date of death is 2005. Hmm? Earlier you had filed another way. Where is the report? At page 56. At page 56, you have annexed a letter issued by the block medical officer of health.
Letter to the director.
Where is the report? You have annexed this. This letter, please read the last line of this letter. No, where is the report? It was here, it was along with this letter. Where is it? You have annexed the letter. How you can say no report has been received?
Send to the petitioner, my lord, only this. Only
Sir, this letter, then you would have said in the OA that report was not submitted. Where have you said?
no report, sir.
Where have you said that only the letter was served without the report? Don't just make any submission in here.
This letter was
Only this letter, that report is part of this letter. It is not separate. No, no, we will not accept such submission.
Director of health services issued this letter, only this, page 54.
What is that page 54? This letter issued by the BMOH, it says that a report is being submitted. That report is part of this letter. You don't know. As your petitioner said, that only the letter was served without report. Has he said so anywhere? How as a counsel you can make such submission?
No report with me.
We don't accept such submission from advocate. Either he has to say what his pleading is on the fact. How can you say regarding facts whether it has been served in full or part? You cannot say, will not accept.
Such a matter, this letter issued by the director of health services, 2 letters, maybe a report, nothing.
That is a report of the BMOH. Where is that report? We are asking you for a specific purpose. Your father has, he's your father. Your father passed away in January 2005. Now this BMOH says that in time you had made the application. So in time means before April or before May? No, before July. You must have made the application before July 2015, within 6 months.
In that they send it with the receipt copy of the applicant to consider the service. Which report is not well, it has not been served.
No, no, no. There is no such averment. We will not accept this submission. Why you have not enclosed that we are asking. Because you come to the next sentence. What is the date given? He says that application was submitted in due time. On which date? See the date which is mentioned. See that letter at page 56. Please read that letter, sir. It is also noted that so and so claimed his service. Read it. Claimed his service compassionate ground in due time on 6/4/15. 6/4/15 is in due time after 10 years. What? No, no.
6/4/2005. This is by the BMOH.
Where is that?
Can you see this page 56? Page
56.
Can you see receipt and pages?
Where is he? Page 56 is this communication. This is page 56C. Therefore, we are asking you, where is the report? This says that application was received on 6/4/15. That cannot be. That is the wrong date. Page 43.
Six, 2005. 6th April.
6/4/2005. This is in Bengali. What does it say? Mr. Mukherjee, see page 43. Page 43. Everybody's paging is different.
No, that's all right. What is this? What is said in the bottom? That's all. And what is this? It's a
compassionate service in favor of Sandeep Chakraborty, son of late Jagadish Chakraborty, ex-GD.
How I will understand what you have written in the application?
In Bengali. Bengali received it by the DOMH.
Sir, be kind to me also. How I will understand? Huh?
Second judge will come.
So I should rely on wonderful.
It could appear by the DOMH. 6/4/2005. And same was
So this is on page. Does in the body of this letter has the applicant stated anywhere that he is submitting the pro forma? Read the letter. I can't read it, sir. Please read it. Mr. Mukherjee, see if it says anything about pro forma.
only plain paper is applied to the authority. Authority received this mail.
Then this does not change anything. Then everything remains the same.
After this letter, the proceeding was started by the chief medical
Then this
officer
does
of
not
health.
change any situation.
Chief medical officer of health and chief medical officer of issued a letter to
When the claim was rejected in 2014.
Lordship rejected
14 or 15 when it was rejected. No, in 14, I remember I have gone through. No, sir, 1/4/2015.
2014.
1/4/2014.
1/4/2014. Then, my lord, they said letter, after this said letter, and next page, my lord, kindly see next page.
Yes.
The medical officer, my lord, and issued the letter to the petitioner.
Yes.
Stating that he has got employment on compassionate ground in respect of.
So he was communicated in 15. In 15.
14, director issued the letter. 15. Then this 1 year after, GMH issued the letter to the petitioner. Then that's it. Next page, my lord, the block medical officer issued the letter to the director.
So based on this communication of 16/7/2015, you have made an application again.
Again, the petitioner waiting for consideration, waiting for after this letter, my lord, GMH was waiting for then make further declaration to the director of health.
Yes.
No action.
That representation is of 2018, after 3 years.
Waiting, he is waiting, my lord, after DMH issued the letter. After DMH issued the letter, he is waiting for case was considered. Then file this application before the time.
The issue is whether this furnishes a fresh cause of action.
Yes, in your opposition, what you have stated about this letter of 16/7/15?
Saying only this, my lord, application not format paper. Not format paper. Only this point. Or already case at the time of
Have you said anything about this communication of 16/7/15?
maybe consider.
they have said about this. It's fine.
You have not said anything about that communication.
For 6th April 2005. But 2002 circular. 6 months from the it took place on
Only this one.
7 January. Before this OA, you have filed another OA. This is the first OA. Why you have filed the OA after 3 years?
Within 4 months after death of his father,
Yes.
then some proceeding would continue.
How?
Proceeding would continue. The COM, Chief Medical Officer, issued a letter to him. And no objection by before the first class magistrate. And that was it. And it was said the director. The director said
22nd April 2015, your claim was rejected.
rejected. Then DMH passed the letter to the director. It is not listed on the part of the petitioner, it is part of the office. Then I am waiting my lord for consideration.
For 3 years.
Waiting my lord, they will consider. Then
This communication of 16/7/15, that does not give anything fresh. It is referring to that same application which has already been considered.
tribunal said file an application for condemnation of the that was considered. That was considered by the Honorable High Court.
Delay was condoned. Where is that order?
Here. High Court, my lord.
High Court.
Oh, yes, they rejected them, then I come to the High Court.
Let us see. I think High Court.
Page 22.
All your paging is messed up. Which 24? Yep. I can't find it. Your paging is all messed up. Annexure? There are 3 page 24s. Which page? No, this is not condonation. This is remitting the matter to the tribunal. Where is the condonation order? So where is the order passed on MA 39 of 22?
That order below tribunal passed this.
Where is the order passed on MA 39 of 22? No order passed.
Adjournment.
No, this is not order passed in MA. Where is the order passed in MA? Why? Then there is no condonation. Then how the final order was passed? Without condonation, how the final order can be passed?
After this final.
That we have understood. Again, we are asking you, without condoning delay, how the order can be passed?
After this order of the director, it's returned to the director, then I working for consideration. Thereafter, I make an application.
So you have not pressed your MA. You have not pressed your MA. You have filed MA, but you have not pressed it.
After the order, I produce this order, we put the tribunal, then
No condonation. There is no condonation. There is no condonation. So that tribunal wants that it should be filed along. It is not filed with the he has not pressed. That pressed into that. And is if we remand it now, that could be considered. Yes, order is sustainable without condoning delay.
Without condoning the delay, the tribunal will discuss on the merits.
after the order passed,
How many times you will say that, sir? This is the fourth time you are saying that. How many times you will say that? The point is there is no order passed on the condonation application. Then how the order is sustainable? Unless delay is controlled, how the
director. No against the order, any order passed by the director. And no.
you have filed MA application for condoning the delay. What are you submitting? You have filed the MA application. You just can't say anything. No, not as per direction. So as per direction of the tribunal, you go home. Why you are here? What is this? As per direction of the tribunal. You have filed MA, you have not pressed. The same thing you are saying again and again.
or upon the trial
Has to be satisfied.
upon the delay
That's to do. Tribunal is not for.
by the subsequent
The proper course is to send it back to the tribunal, but tribunal is not functioning right now.
application condemnation.
Tribunal is functioning, no.
Last date was 15th October. Officially, I have got information that is better, but I cannot say that somebody has been recommended, members have been recommended, filing is lying with His Excellency.
Because this has to go back to the tribunal. Without deciding the condonation application, how it can be decided? Cannot be decided. But right now, remanding it to a tribunal which does not exist, what can be done? That is why we are thinking what to do.
At the present moment, but the members, chairman has been selected, members have been two judicial member, administrative member, one judicial member has already been selected.
So it is in the process.
So file lying with His Excellency.
Because condoning, without condoning delay, if the order has been passed, it is not sustainable.
Supreme Court judgment is there. Oral condemnation, oral submission of condemnation has become considered.
But their order has to be recorded.
He is just submitting anything. That is the problem. He is saying anything that comes to his mind. We will condone the tribunal's delay, or the tribunal has to condone its delay. Where is that judgment? Show us. Which judgment you are relying upon?
I have not today it is not yet with me.
Come with that judgment. We find that the
Second 30.
Krishna, I'm praying for not to.
Item 31. Item 32.
You have already filed up. You have already filed up.
Copy has been served. Same order. Same order. It's all loose. It is not bound.
Item 33.
Time for the appellant. The affidavit in reply kindly takes some reference. The affidavit in reply we can kept to the reference. One of the petitioner was appointed as a temporary employee, and lordship the petitioner was engaged for last 33 years, and lordship the petitioner was last. The lordship kindly come the impugn order, then it will be clear. May I place the order impugn portions? A certificate given by the subdivision officer, Vizora Education Subdivision, Board 1, addressed to the executive engineer dated 6/6/2014 shows the name of the applicant. It was engaged since 14 August 1987. It appears that the applicant was an agricultural laborer whose engagement was made during the Boro and Kharif irrigation seasons. By another letter, the same officer requests the executive engineer to approve engagement of 10 laborers for guarding improvement regulating gates during the Kharif irrigation seasons 2004. A copy of the representation in this application is also referred by the learned counsel. The representation neither has signature nor the dates. The contention of the applicant side is that the applicant had worked for more than 10 years during 1987 to 2013 and performed his duties more than 240 days in a year. By such service, the applicant is entitled to the financial benefits as stipulated in the memo number such and such dated 15 September 2011 and also by the memo number such and such 25 February 2016. It is not in doubt that the applicant was engaged is an agricultural laborer since 14 August 1987, may have performed at least 240 days in a year. However, the clause 10 of such and such clear that such benefits are not to be given to any contractual engagement made without sanction post for any specific. The applicant side is not able to present any copies of document which shows the engagement even contractual was against sanction post or any specific project. Mr. Banerjee, Learned Counsel, Lordship. This is the benefit and the Lordship, the impugn order itself is clear that the petitioner has performed more than 10 years and 240 days has already, Lordship, if I, Lordship, come to my affidavit reply.
What material you have placed before the tribunal in support of your contention that you have worked for 10 years and 240 days in every year? What is the material before the tribunal?
I had made an applications annexure. Lordship, kindly come to the annexure 29, which was
Page
29. Yes. Page 29. The permission and approval was submission officer to be here, such and such. Here, Lordship, the petitioner name is there. This is one. And Lordship, the next one also on.
Again, we are asking you the same question. What material you have placed before the tribunal which shows that you have worked for 10 years and in all the 10 years you have worked for 240 days? What is the material before the tribunal?
Letter was.
Then how it can be granted? You know that 1611, this, what is the date of that? September 2011 notification. 16 November, September 11. Unless you have worked continuously for 10 years and have 240 days, you cannot be considered. So therefore we ask you, what is the material to show that you have worked for 10 years and 240 days in every year?
As such, Lordship, this type of questions does not arise to me, and the London Tribunal did not ask.
That question arises to you because you are relying on the notification. Once you rely on a notification, you are obliged to show that you are entitled to the benefit. So you have to show, you can't say no question arises.
I have stated in my affidavit reply.
If that is enough, then everyone will get the benefit of this notification. Then everyone should get. They should give in writing before the tribunal that I have worked 10 years and they will get it.
Lordship, what materials, Lordship, was not on the first date of office.
Again, we are asking you, have you given any proof that you have worked for 10 years, 240 days in every year? In the OA, show us.
Except this letter, I do not.
Then what can be done? Then nothing can be done.
Then liberty will be given again to place all the documents relevant to these questions. Because at that time, the first date of hearing, this was not issues, even I was not.
That is the not required. You are not required to be asked. You are required to place it before the tribunal along with your OA. Because you are relying on this notification. You have to make out your case. Heard learned counsel for the writ petitioner.
My only question.
Same. Let us see. Give the file. With today 33, 34, 33, 34. And what is the date of engagement? Same. No, sir, it is not same. Here it is 29/8/17. There it is something.
What are the different, but all the same.
No, no.
All
That petitioner was not engaged on 29/8/87. Huh. Date of engagement is different.
date of engagement is different, but the imping order is same.
That is, so we asked you whether the date is different. But it is in 87. Both are 87.
Both are the same name.
87, we have not given the specific date. Engaged in 87. Same order. Agricultural labor. Engagement in 87. First paragraph. So it is same order.
Affidavit on reply we kept.
Yes, affidavit of service we kept on record.
Otherwise, it will be if indefinitely.
We don't know whether you will challenge our order. We do.
Twenty-five. I have just received the affidavit in opposition filed as per the direct.
Opposition is being filed.
Right.
It has been served on you.
I have. I am praying for leave just to file the reply. Day before yesterday, I received the position.